Mr. McHenry, how many immigration judges do you anticipate hiring and onboarding in the upcoming fiscal year?
It's hard to say for the entire fiscal year. We have 19 that are currently in the pipeline, and we're in the process of hiring up to 42 additional ones. So that would be a total of 61. Beyond that, it will depend on factors such as availability, retirements, and things like that, but at least 61 by the spring of next year.
Okay, what step is EOIR taking to begin the process of converting to an e-filing system?
We have had several meetings with our Office of Information Technology, and I've made it clear in no uncertain terms that e-filing, an electronic case system, is an absolute priority for the agency. We've begun developing a process to pilot an electronic filing system next year, but it's more than just an electronic filing system. It's an overall electronic case management system. We're in the process of developing the prototype for it now and soliciting additional feedback. But I'm confident that we will have a pilot of some type in one or more immigration courts by 2018.
Okay. Judge Keller's memorandum of July 2017 provided the framework for continuances in immigration court. How is EOIR able to enforce that memorandum and ensure that immigration judges are not overtly ignoring it when ruling on continuances?
The memorandum, by its own terms, it's an operating policies and procedures memorandum, doesn't direct a determination in specific cases. It does remind judges, however, of considerations they should keep in mind regarding docket efficiencies when entertaining certain types of continuance requests. That memorandum was issued at the end of July, so we've just come upon about a 3-month window since it went into effect, and we're just now getting the data to analyze it. Once we review the data and see what it shows, then we'll take appropriate steps, if necessary, to go back and revisit it.
Do you have any preliminary findings from the data you've looked at so far?
We had a couple of initial findings, but there seemed to be some data quality issues, and that's why we're going back and double-checking them.
Okay. Much of today's hearing focuses on the backlog, which, as previously stated, stands at about 630,000 pending cases. To what extent do you believe that the reallocation of resources and judges to so-called priority dockets of unaccompanied minors and family units beginning in 2014 contributed to the backlog?
I don't believe there's any question that it contributed to the backlog in a significant way. A measurement of the precise magnitude is perhaps a little difficult to come by, but it's clear, especially unaccompanied alien children cases, they typically take longer to resolve than other cases, other immigration cases, for various reasons. So by putting them to the front of the line, you put cases that take longer to resolve first, and then you continue cases that otherwise might have been resolved in their place. So it's had a significant impact. As I said, though, I'm not sure that we can...
So it's almost the opposite of triage, that we actually put the ones that take the longest in the beginning instead of taking care of the ones that we could handle right away.
It was a system that was counterproductive, I think, to its stated goal of trying to resolve the cases more quickly.
Does EOIR still prioritize these cases?
We changed our priorities for the third time in 3 years in January of this year. That was before I became acting director, so I can't speak entirely to the process that drove that. Currently, our priorities regarding unaccompanied children are only those who are in the custody of the Department of Health and Human Services. Other unaccompanied alien children are no longer considered a priority, but I can say that within the agency, within EOIR as a whole, myself and my senior management team are reviewing our overall priorities in general, and looking at whether that priorities memo, the last one that we issued, is still the best statement of how we look at cases.
As EOIR is considering instituting certain performance metrics for immigration judges, including possible case completion goals, how would you expect such metrics to impact the current backlog?
Well, EOIR already operates under a number of performance metrics. Some of those are established by the Immigration and Nationality Act. Some of those have been developed by the Government Performance and Results Act, or GPRA. Those results have been positive so far, the goals that we do have. We would anticipate if we develop new goals, and we've been recommended to do those by the GAO, the Office of the Inspector General, by Congress. If we develop those new goals, we would expect the judges to be able to comply with those as well. We feel our judges are professional enough that they can understand the importance of adjudicating cases while at the same time maintaining due process in each individual case.
So, according to track data, the average number of days that a case is pending before the immigration court is 691. It seems that it is meaningless for ICE to apprehend individuals and place them into removal proceedings if they will then be in limbo for over 2 years before there is final disposition of their case. What is EOIR doing to reduce this average number of days pending?
Our data, I think, I don't have it in terms of days, I have it in terms of month, that the average pending non-detained case is approximately 21 months. But we are trying to reduce that. As I mentioned, we're looking at docketing efficiencies, we're looking at instituting specialized dockets to try to consolidate cases, achieve efficiencies of scale. We're also committed to no more dark courtrooms. Whenever we have a judge who's absent, we're going to have either by VTC or a retired immigration judge be able to hear those cases in those absence. Together, that should start bringing the average down.